everyone, this is Gilbert Jalad. I'm talking to you here from Private Corporate Counsel downtown Orlando. This is Tufts on Tax, where all your tax issues and questions are answered right here with Mr. T. Scott Tufts. He is the master when it comes to taxes and tax laws. Hello, Scott. How are you?
Good to be with you.
Good to be with you, too. Now, folks, you can always call us at 877-647-7887. Again, that number is 877-647-7887. Or you can email Mr. T. Scott Tufts as stufts@pcc.law. Again, that is stufts@pcc.law. Hello, Scott, and what are we talking about today? I see that we have on the agenda phantom income on your K-1 might not be taxable. What is this all about?
Yeah, so we have spent a number of prior episodes on the K-1 or even a 1099 and made the point that it's a starting point, it's not the end point. It can be in error, it could have issues, and so that's kind of the first step. But there's also the idea that many folks will see a K-1 and have some income on it, and they won't get any corresponding distributions to help pay the tax. So in other words, it will report maybe just hypothetically $50,000 of income, but there's no money to pay the tax, and they will invariably say that can't be right. You know, it can't. If I didn't get $50,000, how can I pay tax on it? Well, what happens is if you are in an LLC or entity that is reinvesting the income, in other words, they're not distributing it to its owners, they are just taking the profits and reinvesting them in business, then you've gotten the benefit of being a member to the extent of that increase in income, even if you didn't physically get it. In other words, it's almost as if they handed you the profits and you returned the profits, and therefore you would be paying tax on how well you're doing, so to speak. So when we hear the term phantom income, we need to break it down a little bit more, right? So when folks say phantom income, it's a starting point, not an end point, because you have to unpack it. And do you know what I mean by unpack it? You have to get into the details of why is it phantom income, right? So the first example I've given is it's phantom income because it doesn't feel like I should be taxed on it because I didn't get any cash or distributions with regard to that amount. Make sense?
Yep.
All right, so what happened now in the Joseph C. v. Director case in March of 2023 is out of the Tax Court of New Jersey. And what gets interesting about New Jersey and maybe other states is that they do not necessarily have a tax system that is in line with the federal tax system. So we oftentimes think of our states just working hand in hand with the federal approach, but that may not be the case. And so here's what gets interesting about the Joseph C. case, the direct versus the New Jersey Department of Revenue. They're called the Division of Taxation there. According to what this case is saying, and what I understand is happening, $2.3 million of an amount of a gain was reported on the K-1 issued to one of the members in an LLC, and the LLC had essentially over time had been it had a patent on an energy drink bottle in which the powdered supplement to the liquid could be mixed immediately before consumption. Over time, the venture attracted professional investors, which were thought of as angel investors. Annual losses, though, reduced what was originally this particular member's capital account from the $1.1 million that he originally invested down to a negative 7.7 million. So if you follow what's going on, Gilbert, you put up 1.1 million and it's losing money at some point. Well, the way the tax system works and the partnership accountings work and LLCs is you keep track of your money in, right? So if you have 1.1 million, that's kind of almost like a basis or capital account. And if the performance over a number of years leads to significant losses, your account may go negative because it's keeping track of those losses. And so sure enough, he had a negative balance in his capital account of 7.7 million.
Wow, that's a
Right.
big amount to be negative.
Yeah, and the business declares bankruptcy. So at that point, what the question becomes is, well, at the end of the day, when you liquidate and file a final return, your capital account should zero out. And so many of our audience will know what we're talking about. So when his negative $7.7 million capital account was then addressed and went through the kind of various aspects of the liquidation, there was some cancellation of indebtedness income and so forth and so on. But at the end of the day, there was this $2.3 million amount left that he did not, that was used to zero out his capital account and basically bring it back to zero. So the box one of his final K-1 had income of 2.3 million, but there were no funds or assets distributed to him on box 19 of the K-1, and the director in New Jersey of the tax system there said, well, that must be income to you, okay? So the 2.3 million is appearing on a box one of your K-1 to do nothing more than to zero out the account and bring it back to zero, okay? Mm-hmm. And the question becomes, was that going to be taxable in New Jersey? And the interesting thing that happens in New Jersey that doesn't happen at the federal level is New Jersey has tried to approach taxes in a different way, so that if you have a type of income tracking through to you that is paper only and doesn't have any substance, they are not inclined to tax that in New Jersey, okay? So the long and short of this is that there's a lot of particulars here that our audience needs to be careful with. For example, many agreements are drafted with something that we call a DRO, a deficit restoration obligation. That would mean that if you get the benefit of losses so many years and you go negative in your capital account, you have to restore that negative capital account because you've gotten the benefit of losses. And, you know, so the theory is you should return those losses back to the company at the end of the day, or at least that it's an obligation of some kind. Well, that may not be your business deal. You may say, nope, if we lose money, we lose money, right? And if we have losses that benefit me because I had so much of a stake in the business, then so be it, okay? So, for example, in box 11 of his K-1, he was allocated 3.7 million of what we call cancellation of debt income. So, in other words, the business is owes money. It's canceled as a result of the bankruptcy. The question is, there's more things on his K-1, Gilbert, than just box one. There's another box that says we're allocating to you 3.7 million of federally taxable cancellation of debt income. And in New Jersey, under their particular state laws, they do not tax that in New Jersey. So this is kind of why, at the end of the day, we can't even use a term like phantom income without being very careful about unpacking it and understand, well, what are the laws to break that down, okay? And in this case, what I found interesting is they said the approach that the Department of Revenue wanted to take in New Jersey was that they wanted to treat it as somehow being taxable because it was a liquidation of the business rather than a sale of your interest, okay? And what they said is, the court says, well, wait a minute, that distinction does not make sense since it places a taxpayer who lost all of his or her capital in a worse position than the taxpayer who had his capital returned. The economic reality is he did not gain or lose anything from a ledger transaction. And this gets me thinking about some of the cryptocurrency situation where something occurs on a ledger and it hasn't been sufficiently forked or changed into a new account that should result in a taxable moment in time. But anyway, not to digress, the main thing is they point out that because he got no money from the liquidation and because he did not receive a return of capital and he did not have a deficit restoration obligation, then he did not derive an economic benefit from the allocated income. And so therefore, without any return of capital or an economic benefit, and there was no recovery of a past tax benefit, and so their approach was to say not taxable in New Jersey, not at the federal level, but in New Jersey. And one of the last things they say is, we're not going to let people, if you don't do something like this and tax it properly, they said if you don't do something like this properly, you're going to encourage straw sales to nominal entities or dummy corporations just to avoid the proposed tax. And so, Gilbert, we come full circle now with this idea that does the tax make sense on your form? And what we want to get across to our audience is that you have a lot to unpack. Like in this case, your K-1 might go to both a federal authority and then your state tax system. And folks that are either doing business in a state that taxes income or are impacted or reside in a place that has a tax at a state level, you cannot assume that your state tax system will march along and be the same as your federal tax. So the long and short of today's episode is we cannot use terms and labels without really doing a deeper dive and analyze what's going on. And I think as fast as society gets these days, we need to know that the K-1 is a starting point, not an ending point. And terms like phantom income are nice to use to help kind of break it down and describe your dilemma or your problem or your issue, but you need to unpack it and really look deeper at what is going on. And I think when we start to think like that, look, the bottom line is we have a complex tax system. It's not a simple tax system. And even though New Jersey is trying to simplify their particular tax system, it doesn't mean that it's still as simple as maybe ideal. And therefore, with all of these terms, with all of these forms, with all of these questions, with all of these boxes on the form, I think our audience ought to say, wait a minute, if it's that complex, then I expect it then to not have an easy answer. And if they don't run off with the easy answer, then maybe they can protect themselves as consumers by looking a little deeper at their situation. And so that's kind of where I would go with this, is that folks out there, if you've got questions and you are looking at something, try not to do the knee-jerk reaction. Try to get underneath the hood, look at all the parts and everything moving, and see, and then get to someone who knows what they're doing, right? Because at the end of the day, you also have the idea that if it is complex, are you getting to the right people? And so make sure that the people in the trenches that are helping you have the expertise necessary at the level of your issues and problems, and do your best to also check that out. And then if the problems still remain, or you're battling an issue that you're fighting or whatever, then someone like myself can also step in. So that's kind of where it goes.
Absolutely. Well said, Scott.
So we talked about this so many times, dive deeper, make sure, check things, ask the proper source to make sure that you are doing everything right. You don't want to reach a point that you're in a lawsuit or litigation that is, very complex. Well, guys, if you have any questions, if you are in situations just like this or similar to this, please call Mr. T. Scott Tufts. He will help you. He is there just to help you with situations like that and similar to that. 877-647-7887. Again, that number is 877-647-7887. Or you can email him at stufts@pcc.law. Again, that TUFTS@pcc.law, or you can visit our website as well and check him out at privatecorporatecounsel.com. Thank you, and to the next episode next time. Bye.